All right, an arraignment in a murder case that really shocked Pike County in Ohio, and we're covering it here on Law and Crime. I want to get the reaction to all this right now with our very own Law and Crime trial analyst, Gene Rossi, who always has a great perspective on any case that we cover. So, Gene, welcome. I'm curious your thoughts as we listen to this arraignment, because the details of this whole case are really bizarre.
Yes, and my mind's exploding, and I'll tell you why. Putting aside the charges, I had so many arraignments I couldn't tell you, hundreds if not 1,000. And at only one arraignment, Jesse, did the defendant ask that the indictment be fully read. I don't know what the procedure is in Ohio, but at an arraignment, usually the defense attorney says we waive arraignment, we waive a reading. And I think the defendant said, I want the entire indictment read. It only happened to me once.
What's the benefit there?
There's no benefit. All you're doing is, and this happened to me once when I was a prosecutor, in 2000, United States versus Taki, Washington, he asked the judge for the full reading of the 9-page indictment. The judge was livid. This judge, to his credit, is showing a lot of patience, and he's reading the indictment. In my case, the clerk read it. In this case, it's the judge. Now, Jesse, I gotta say this. I don't know what the practice and procedure is in this state court before this judge, but 99% of the time you waive reading of the indictment at an arraignment.
And what an indictment it is. Let's continue on. We're listening to the details of what happened, or what allegedly happened, to the Roden family. Okay, so that indictment is still being read. I want to bring in Gene Rossi to break it down right now. Gene, okay, so the motive here is still a little circumspect. It could have been what we seem to believe it has something to do with a custody fight, a custody battle over one of the members of the Roden family. The question is, though, it seems investigators are being tight-lipped about this. Why do you think that is? I mean, they're not going to provide specifics right now. What do you think's happening?
Because there's probably more subjects and targets on their list of people that they may charge. Whenever you keep the details of an investigation secret until you absolutely have to, is you have a continuing investigation. If everything occurred and that was it, it would be all in the indictment and it would be exposed to the public. But they're still looking for other people who may be involved in this horrendous conspiracy that just blows my mind.
Yeah, I don't think I've ever heard anything quite like this before. Two families in this kind of circumstances. Have you ever seen anything like this?
No, I've had in my drug cases families that, you know, may have exchanged a few harsh words and threatened violence, but never this. And I think one of your colleagues or associates up there mentioned the Hatfields and McCoys. I think I'm going to start reading this about that duel this weekend, because it sounds like there was a lot of pent-up anger between these two families, and it just crossed that Rubicon to violence and murder.
I'm going to ask you the question that I asked John Spilbor. So you have these family members all being charged, similar counts. Do you predict, I mean, again, we're still trying to see the details of this case, do you predict maybe there would be a plea deal for one in exchange for testifying against another?
That's a fantastic question. I suspect they're all going to go to trial, and it's going to be sort of like the mafia. I'm Italian, so I can say this. It'd be like the mafia. They're all going to go to trial. They're all going to sit at the table. You're going to have 4 defendants, probably eight defense attorneys. I don't think one's going to cooperate against the other. No.
Okay. Well, I mean, we got a lot to see in this case. Here's what we're going to do, though. This arraignment is still going on, but we're going to take a break. When we come back, though, we definitely want to dip into our further discussion about the cop cover-up trial, because we anticipate a live feed in that courtroom in about a half hour. So let's take a quick break, and we're going to switch gears when we come back here on Law and Crime. Okay, Gene, let's go back. Let's look at Jason Van Dyke's testimony there about the idea of Laquan McDonald still being a threat while he was on the ground and while Jason Van Dyke shot him multiple times. Your perspective on hearing him take the stand and bringing up that issue?
I've seen this so many times. When a defendant takes a stand like Van Dyke, and you have a prosecutor who is just getting under his skin, and this prosecutor is doing a very good job of just getting in his head. And he is very short, curt, borderline sarcastic. And I got to tell you, the more I see his testimony, it doesn't surprise me that the jury deliberated in a relatively short time for these very serious charges. He wasn't a good witness for himself.
Was he being evasive, or was he being annoyed, or really did he not remember what he ultimately said in the report? And we're going to talk about that report in a second.
I think on this point that he, no pun intended, he said that McDonald was pointing the knife at him, and he said that to Officer March, and he now doesn't remember that. I don't think that was truthful. Number two, I think he just feels that I was trying to do my job. It's a dangerous job, and, you know, you're charging me for murder? Please. That's the attitude that he's telling me by his demeanor.
Okay, well, let's see how this matches up, because the police reports of these detectives were read in court yesterday, and particularly David March. We had Joseph Perfetti from the Record Services Division, from the Chicago Police Department, who read these reports. Let's see how that report matches up to what Jason Van Dyke just said. So the argument is that this report, prepared by the defendant, really is presenting facts that are not accurate. I'm back here with Gene Rossi. Now, Gene, the counter-argument to that could be, and we heard the defense counsel for David March say, hey, he just reported what was told to him. This isn't a cover-up.
Well, you know, when you see a report or read a report that has what I call bromides, active assailant, attack, that lends itself to they got together and they came up with this story. But I will say this, it is a defense that Officer March was told certain information from another officer, and March put it in his report. He didn't do it with any willfulness or intent to deceive. That is a possible defense, that I relied on the good judgment and the sound advice of fellow officers, and I incorporated that in my report. That is, in fact, a possible defense, and it could carry weight with this judge.
Okay, so let's break this down, right? If they can successfully prove that this was sloppy police work, that they didn't fully investigate as much as they should have, not because they were trying to protect Jason Van Dyke, but because they just took the word of different officers and didn't do a thorough enough job, could they be found guilty of conspiracy, obstruction of justice, or official misconduct?
No, because those charges are specific intent charges. And I'll go to federal criminal tax cases. If you have a person who's a sloppy taxpayer or a sloppy accountant, and they just don't cross their T and dot their I's, they'll never be charged or will be able to be convicted criminally because the level of intent is so high. Mm-hmm. The charges against these three officers is obstruction of justice, willfulness. You have to have almost an evil intent and a higher level of intent to commit these crimes. Sloppiness and negligence results in acquittals, and that would be a defense.
Well, you could argue it was a strong day for the prosecution yesterday, but Gene is making some really good points about the law and how it might be difficult to actually prove this case. Let's take a quick break, and we'll be back with more discussion. Okay, let's break this down. I'm back here, Gene Rossi. Gene, we're trying to understand whether or not these reports were falsified, whether there was something nefarious going on here. Do you think there's something improper by labeling the victims as Jason Van Dyke, two of the defendants, and Officer Joseph McGilligot? Is there something improper by saying this was a cutting instrument? Is there something improper by classifying Laquan McDonald as an offender and a criminal who attacked an officer? Is there something wrong here?
Yes, there is, and I'll tell you why. It goes back to that video. To say that Mr. McDonald, the victim, was an active assailant and on the verge of attack, and to put that in the report and imply that he was a deranged, high on PCP individual, that goes from the gray area to the criminal area. And I see what the prosecutor's doing is that they're engaging in incredible exaggeration, and that incredible exaggeration raises the intent to willfulness and obstruction of justice.
Yeah, and that's really what they're trying to do here, and that's why you can argue it was a strong day in court for the prosecution. But one of the officers that we mentioned was Joseph McGilligot, who was labeled as a victim. Remember, he testified in the Jason Van Dyke trial. Let's just see what he had to say back in that day. Okay, Gene, let's talk about this, right? So you just heard some of the direct examination, some of the cross-examination of Officer Joseph McGilligot. In your opinion, is it appropriate to classify him as a victim in those police reports?
Well, the defense attorney's trying to make him a victim. Based on what McGilligot said on direct, he didn't seem to be a victim. He didn't feel he was a victim. It was a tense situation, but he shouldn't be listed as a victim in a report. On cross-examination, the defense attorney's trying to say, you know what, officer, you really were a victim. Let me tell you why. So it's a strange dynamic. I do want to compliment the defense attorney. He has a good style, good demeanor, very respectful. He's getting in the best points he can. But when you're trying to make a cop a victim when they don't feel they're a victim, that's putting a square peg in a round hole.
Now, one of the interesting aspects is this is a bench trial. It's not a jury trial. Is this more a situation where these attorneys they're saying, listen, let's break this down from a legal aspect, Judge. You might be able to understand this. You might be able to process this a little bit differently than a jury. How does that play into this?
Absolutely. Bench trials and jury trials are totally different in terms of strategy. And it depends on the judge. If you have a judge that is all business, Joe Friday, and doesn't like histrionics, you aren't going to try to be Clarence Darrow in front of that judge. A jury's a different animal. It's a production. You got 12 people, maybe 15 with the alternates. It's a production. You're trying to appeal not only to their rationale, their reasons, but their emotion. A judge is a different animal. No pun intended. No disrespect.
Right.
It's totally different.
Absolutely. Gene, thank you so much for being on with me. Stick around because Bob Bianchi's coming on, and he's going to guide everybody through the next chapter of this case because we expect to be live in about 5 minutes in the second day of this trial. We'll be right back.